Hi, everybody. Welcome to your lesson video on the judicial branch and the Supreme Court. So the judicial branch of the national government includes many different levels of federal courts. For example, if you were arrested for drug trafficking, you were trying to smuggle drugs into the country, you would find yourself in a federal court, probably one of the lower level federal courts, and you would have a trial and they would determine whether you were guilty or not. And if something went wrong in your court case and you decided that you wanted to appeal the verdict, you thought something was unfair during your trial, you could potentially have another trial in a higher level court, and so on and so forth. But the highest level court in the judicial branch of the federal government is the United States Supreme Court. And it is the Supreme Court who acts as a referee. Their job is not so much to decide criminal cases. So if you break a national law, you're probably not going to end up in the Supreme Court. Instead, what the Supreme Court does is they interpret the words of the Constitution, and they have this power of judicial review. So you're really only going to find yourself in Supreme Court if you're claiming the government has broken one of the rules of the Constitution, or that a law passed by the government is violating one of your rights. So this power of judicial review means the power to decide if the other two branches, that would be the legislative branch and the executive branch, are following the rules of the Constitution. And the Supreme Court can decide that something is unconstitutional. If they rule that something is unconstitutional, it's like throwing a penalty flag on a play in a football game, and that action or that law must immediately stop. Now, the Supreme Court of the United States is made up of 9 judges. They are sometimes called justices. These justices are appointed by the president, and they must be approved by Congress. But once they are appointed to the Supreme Court and approved for that position, they serve for life. They will serve as long as they choose to serve. The only way that a Supreme Court judge leaves the Supreme Court is if they die, if they choose to retire, or it is conceivable they can be impeached for crimes. I do not believe that has ever happened in the history of the United States, that we have had a Supreme Court judge impeached. So the catch here is, even though the president chooses the Supreme Court judges, presidents only get to do that if a Supreme Court judge happens to retire or die during their term in office as president. So some presidents have a chance to choose 1, 2, even potentially 3 Supreme Court judges during their time in office. Other presidents never have a chance at all to appoint a Supreme Court judge. Now, Congress does technically have the power to change the number of judges on the Supreme Court, but there have been 9 judges on that court since 1869. And when you change the number of judges on the Supreme Court, it's often referred to as court packing. And that term really refers to the fact that a certain political party maybe takes control of Congress, has a majority in Congress, and then they try to add judges to the Supreme Court so that the majority of the judges on the Supreme Court support their point of view. And for that reason, court packing is generally considered pretty unfair, and really undermines the consistency and stability of the Supreme Court. Now, Supreme Court decisions. The way this works is the Supreme Court is not going to look at every law and every situation going on in the government. They're only going to listen to court cases when a citizen or a group of citizens decides that they want to challenge a law in court and start what we call a lawsuit. For example, in the Supreme Court case you're going to watch a short video about today, The court case is called District of Columbia v., which means versus, Heller. And in that court case, the District of Columbia, which is the government that basically runs the city of Washington, D.C., was being sued by a security guard named Richard Heller because of a certain law that had been passed in the District of Columbia. He felt that the law violated his rights, so he challenged that law in court. And because this was an issue that involved one of the first 10 amendments to the Constitution, the Bill of Rights, that is why his court case was listened to by the Supreme Court. Once the Supreme Court decides on an issue involving the Constitution, that decision is virtually final. I say virtually because there are situations where years later, a new group of judges can change that decision. For the most part, though, what we're looking for is consistency. We don't want the Supreme Court to make a ruling in the year 2000, for example, that it's okay for people to keep guns at home. But then in 2005, they ruled the exact opposite, that people are not allowed to keep guns at home. And then in 2008, they changed their mind again and say, okay, now it's okay for people to keep guns at home. That's a situation we're trying to avoid with the consistency of the Supreme Court ruling. So once they make a ruling or a decision, that decision pretty much sticks. But there are exceptions. For example, in 1896, there was a Supreme Court case called Plessy versus Ferguson, which basically made segregation legal. It made it okay to separate people of different races simply based on the color of their skin or their ethnic heritage. Obviously, a really terrible Supreme Court decision. But years later, in 1954, you had a whole new group of judges. By then, the judges in the Plessy versus Ferguson decision were long gone. And this new group of judges looked at segregation again and said, hey, there's nothing fair about this. And they ruled in Brown versus Board of Education that segregation in schools was illegal. So Supreme Court decisions can change over long periods of time, but in the short term, usually that ruling becomes pretty much the law. So next up, we're going to watch a video on a Supreme Court ruling called District of Columbia v. Heller. And you're going to be asked some questions about that court case. And in this court case, you're going to see how the Bill of Rights is protected by Supreme Court justices who listen to court cases when citizens believe those rights have been violated.
A decisive ruling from the U.S. Supreme Court saying Americans can keep guns at home for self-defense. This is the first time the High Court has offered its interpretation of the Second Amendment, granting the right to keep and bear arms. The 5-4 ruling strikes down a ban on handguns in the nation's capital. The District of Columbia has one of the most restrictive gun laws, designed to stop violence. The city's mayor is vowing to require that residents register their guns.
More handguns in the District of Columbia will only lead to more handgun violence.
The decision was hailed by supporters of gun rights.
It basically told us what Americans had long suspected. We do have an individual right in this country to have guns. The government cannot ban guns, and it cannot regulate guns out of existence.
A security guard, Dick Heller, brought the suit after the district rejected his application to keep a gun in his home on Capitol Hill, a short distance from the Supreme Court. The ruling will most immediately be felt in Washington, where the stiff handgun ban has been law since 1976. Kenneth Barnes Sr. lost his son to gun violence here.
Almost every day we hear about gun violence in Washington, D.C., and yet the Supreme Court says to everybody in the city of Washington, all over the world, let's put more guns in the street. Let's have more guns. Now, what kind of message to a civilized community does that send to a civilized world?
That is an issue D.C. leaders now have to grapple with in a city that has seen more than 8,400 homicides since the gun ban took effect 32 years ago. Lee Powell, The Associated Press.